Good morning.
Good morning.
Good morning, Judge.
Your Honor. Morning, Your Honor.
Hi. Quick question. I've gotten a notification that someone is requesting to record to the cloud. That could just be an artifact of my Zoom, but if somebody's recording, is anybody actively trying to record? Maybe the court reporter?
Yeah, it was me, but it's okay. I
No,
just
no.
seen that you all stream it as well,
Yes,
so it's
yes.
all. I just like to have a copy for my
I
records.
totally understand, and I assumed it was probably you, but just wanted to make sure. Thank you, ma'am.
Yes, ma'am. No worries. Thank you, Your Honor.
Okay, everyone. We are here on the attorney's fees part two of the Scott Jones versus Jennifer Cummings saga, case number 24CV004197. I had hoped many, many, many times that I had seen some of the back and forth that the parties would reach out and would be able to resolve this. But I assume from all of your presence here and the flurry of briefing that I've seen in the last few days that that did not occur. Is that right, Mr. Howard?
Yes, Judge, we made an effort, but I think we just couldn't agree on a number.
Okay. Well, I'm certain that an effort was made, right? And sometimes you just can't agree. That doesn't mean I wasn't still hoping. Um, Also, just to add to the layer of difficulty, so I have read your briefs, but I do want to. I have a criminal trial we're in the middle of a criminal trial that starts at 10. I probably have an extra few minutes for you, but I'm going to need y'all to keep your presentations as tight as humanly possible because I have to get to that matter. Now, luckily, y'all have all briefed these issues, and I have in particular read. The filing from the two filings from November the 24th, which were the response to the fee award request. And so what I would ask for you to do is focus your efforts on given that I have already said I'm going to award attorney's fees under 91514B, right? I understand from reading the briefs that there are arguments about the scope and extent of any award that I should give based on what the actual relief was that was afforded, which is really sort of a second bite at that original apple. But I understand I'm going to take it as a narrowing tool, right? An argument that any award the court considers should be much narrower than you have this many attorney's fees, so I'm going to give you all of that money. And so if the parties could focus on that, as I said, I have read the briefs. I am aware of the respective arguments the parties are making regarding the quiet title action in particular. And then, of course, the argument about some of the work that the plaintiff did, or a large share of the work that the plaintiff billed for being to recover attorney's fees. So again, with that caveat, it is 9:40. Mr. Howard, I'm gonna start with you because technically it's your motion to recover attorney's fees, but you are sort of in the pole position in the sense that I've already said I'm going to award attorney's fees for you, and you've submitted an application for the entirety of your attorney's fees, which I think, right, but I think it's about $122,000. Is that right?
That's very close, Judge. Yes, ma'am.
Okay. And so if you want to very briefly, I will, what I think would be helpful because as I said, you start in that position, that it would be helpful for you to just very briefly outline what that entitlement is.
Sure.
And then let me throw it over to the other parties that want to challenge it and give you the last word to respond. Because as I said, that's sort of the position that we're in. Mr.
Yeah, thank you. Well, so Judge, I appreciate it. And having gone back through my bills a couple of times, I have tried to separate out the work that we did that was related to the issue of, did Mr. Jones actually own this property? When did he acquire title to this property? Did he actually file an application for abandonment for this property within a couple of years prior to this case, as he says he did? And much of the work that we did was trying to dig out factual issues that we could not get resolved because he was making a false claim that he actually owned the property and had legal title to the property, which he didn't have. So I'm not going to dig back in and say all the incendiary things that were said in the prior motion. But the vast majority of this falls into probably, I would call it 4 phases, right? Phase 1 is he filed his initial petition and he had 3 counts. Count 1 was declaratory judgment, and he is asking for a declaratory judgment that he already owned the property and that he was the sole and exclusive owner of the property, which we know was false. Count 2 was he was seeking ejectment of Miss Cummings, and count 3 was for attorney's fees under 1367 or whatever the chapter title 13 attorney's fees code is, Judge. And that's what ratcheted up the need to try and figure out, does he actually own this property? Because he's saying she's on my property and she's got to get off of it, which we know was not true. So most of the pre-motion to dismiss work, which I would call the first phase of the case leading up to the hearing on the initial motion to dismiss, was trying to figure out 2 things. Thing 1 was, what is this lesson accept provision? And thing 2 was, does he really have title? And what you'd see in my first invoice is that I have 8 hours of time for which I no charged Jennifer Cummings. And that 8 hours of time for which I no charged Jennifer Cummings is me doing things like going back and reading law school treatises and stuff like that, trying to figure out, what is this lesson accept provision and can it be binding here as a matter of law? That's my research on those issues. There may have been 10% or something of that invoice that was me and Madison McMichael going back and forth about that stuff. But I basically told her, this is what we're going to argue, do this. She drafted a motion to dismiss. But the vast majority of the of the work in the first phase of this case was just trying to figure out, he claims he owns this property. How is he saying this? We don't understand it. I would say phase 2 of this case was after Your Honor, and plaintiff claims that we didn't win any of our motion to dismiss. I think Your Honor actually held it in abeyance, although we did win something, because Your Honor said you agreed with us that the city of Atlanta was a necessary party to the litigation, which was an argument that we raised. And by getting the city of Atlanta into the litigation, ultimately we found out who did own legal title to the property, because they sold it to Mr. Jones during the second phase of this case. So the second phase of the case, Mr. Jones did a couple of things. The first thing was that he did not, as he claims, haul off and immediately file a quiet title action. What he tried to do was he tried to do something called vouching the city of Atlanta into the litigation.
I remember, because then I had to go look at treatises and figure out what vouching someone in was. So
that was interesting. Legally, I do not believe that vouching would have worked, and he must have ultimately agreed, because we got an amended pleading in which there was a quiet title claim. Their position on the quiet title claim is that Your Honor told us we had to do it, and they're sort of reasoning their way around to that by saying, well, because of sovereign immunity issues, we had no other means of getting the city of Atlanta into this case. First off, I'm not sure that that's correct. I think they potentially could have sued the city of Atlanta for breach of contract, but without getting into all of that, certainly what the court did not do was tell them that they should file a quiet title action based upon a false claim of ownership, which they knew to be false. So, in order to quiet title, they have to have legal title at the time that they do it. So they filed their second amended complaint. They filed all of the documents that they filed attached to the second amended complaint. A number of revelations came from that. And I would say in that second phase of litigation, I would call that the phase where we were finding out about J.D. Kellum and his company Kelco, and all of the other conveyances that had been made regarding the properties at issue in this case. And so that was a process where now I had to reach out to Kelco, who I did not realize was apparently good buddies with Scott Jones and in a financial relationship with him. Did some discovery, some informal discovery, and then some formal discovery. Met Mr. Kellum's attorney, got some documents, and realized that even if Mr. Jones owned this property as he claimed, he would have given a lien to Mr. Kellum's company, which means that he also didn't have a basis to quiet title. So figuring out all of that was the second phase of the litigation. And then the city of Atlanta, once they got into the case, there was some back and forth doing discovery, trying to figure out from them whether they actually claimed that they owned the property or not, because they were a little cagey about that. I spent some time throughout the invoices going back and forth to City Hall because the city of Atlanta, I guess, changed attorneys during the time of this case. There was one city attorney, and then it became Ms. Perkins Hooker. And the counsel that was actually corresponding with me about discovery requests departed, and the city never told me that she was gone. So I spent several weeks, I would say, emailing back and forth with that lawyer, never getting a response. Eventually, I went to City Hall. I went to the law department. My goal was to try and figure out two things. One, does the city actually claim that it owns this property? And two, has there been an application for its abandonment? And the reason I wanted to know that is because if Mr. Jones, as he claimed, was applying for abandonment of the property currently, then he must know that he didn't own it, which would prove the point that I've been trying to make this whole time, which that he doesn't own the property. I got ran around City Hall for probably a day and a half of people sending me to a variety of different offices before someone finally told me that the attorney had changed and they were sorry. And an attorney named Alexander Hamilton finally corresponded with me. Nice guy, gave me the documents and assured me, well, this is what we're going to do. We're going to sell the property to Jones, and we're going to leave you to fight your litigation fees battle with him. I was a little surprised to see Patrice Perkins Hooker's affidavit attached to their motion, given the fact that their position was we're going to sell them the property and stay out of it. Nevertheless, she filed one. I don't think she said anything that harms our motion or Your Honor's ruling. So that was phase two of the litigation, leading up to, on September 27th, them disclosing, or September 25th or thereabouts, disclosing that they had a quitclaim deed to purchase the property. I think Your Honor may have remarked during the hearing when it was disclosed, Mr. Howard probably going to have something to say about that. That's about the time when I started looking at, what is the viability of a fees claim in this case. I know they complained that we started working on a fees motion prior to litigation concluding, but once I realized that the claim of ownership was factually and demonstrably false, I spent an hour or two looking at those issues, and then the bulk of the fees work was later. The third phase of the litigation, I would say, happened after that. This was the point when I really thought the case probably should be over, but somehow wasn't. The plaintiff's lawyers, you'll recall, dismissed all of their claims except for they refused to dismiss their Title 13 fees claim, Judge. And so I had to file a motion to dismiss that, which was ultimately granted. And they claimed that, well, we continued litigating our declaratory judgment claim after the quitclaim deed was issued, which I think Your Honor must likely, because you denied their motion for attorney's fees, must have agreed with our position, which is that we told the court that we were probably going to dismiss it voluntarily and that there wouldn't be a need to consider the motion. We were just waiting to see if the transactions happened as they said, where they were going to sell the property to Mr. Kellum. Before that, Your Honor entered a motion dismissing it as moot, which is fine. It's not a ruling on the merits, but I don't think that mitigates against our fees. I think the fact that they continued litigating against my client for attorney's fees after this case was over really weighs in our favor, Judge. So then really the final issue is our motion for attorney's fees and their motion for attorney's fees. They seem to have a complaint that we spent $60,000 in fees moving for fees. That's not quite correct. We spent maybe half of that as an amount of money moving for fees. So call it half of the 60 grand, 31 or something like that. The other half we spent defending their motion for attorney's fees, which was again based upon their claim that he owns this property. So because we had to defend all of that, I would say that was all necessarily caused by his false claim of ownership.
Sorry, I was just, my assistant was bringing me more coffee. Sorry about that.
Not a problem. I just wanted to make sure I gave Your Honor opportunity to deal with whatever. So, Judge, most of all of this has been about what is, does he really own this property or not, as he claims? And we never quite got straight answers to any of those questions. I'll note that we did not get disclosure of documents from plaintiff's counsel in response to our request for production of documents until after the quitclaim deed was disclosed to everybody. So They had told us that we would be getting production of documents. They delayed and delayed and delayed, and we were waiting to see what those documents were. And Your Honor knows what most of them are because they were attached to our fees motion. And they absolutely would have, if they'd been disclosed timely, demonstrated that Mr. Jones and his counsel knew that the property was owned by the city of Atlanta at all these times. So they delayed production of documents. Ultimately, we were scrambling once the quitclaim deed was disclosed to go read their production, which got made later, figure out what that said, and figure out how it supported our fees motion. I do not believe $30,000 for a fees motion in a case like this is that outrageous. Their claim seems to be that I over litigated everything, but there were I would say 90% of the pages that we filed in our fees motion were just trying to lay out the actual factual timeline of this case and how the facts progressed. And that took a lot of digging because nobody wanted to disclose anything to us until the quitclaim deed was disclosed. And after that, they seemed to take the position that, well, it's all over now. Here's the documents, you go figure it out. And going and figuring it out is what laid the foundation for our ability to file this motion. So
yeah, let me ask you a quick question, and then I'm going to respectfully cut you off and go to your opponents, and then, as I said, give you an opportunity to respond. But
thank you.
One thing I would like clarification on is you said they have asserted that you spent roughly $60,000, half of the fees that are being sought to be recovered on attorney's fees. And I think I understood your argument to be at least half of that, 30 of the 60, was in defending the fee motion they filed. And so that would mean the other half of it was in filing your own fee motion. Is that roughly accurate?
I think that's the breakdown, Judge. I could get you a specific number if it's going to matter, but I think it's essentially we filed our fees motion and they filed their fees motion on the same day. And then we had to go defend their fees motion. So that was the next phase of it.
Excellent. Thank you, Mr. Howard.
Thank you, Judge.
As I said, I'm going to cut you off now and go on. Am I going to hear from Ms. Jett, or who am I going to hear from first, or all together?
I think, Your Honor, Ms. Bryant's going to go
Yeah,
first.
I'll
And
go
if
first,
I have
Your Honor.
anything for cleanup, I can be
Okay.
very
Good
efficient on
morning.
that.
Good morning, Ms. Bryant. How are you?
I'm okay. I do want to state, just as an initial matter, that I'm a little bit frustrated with the amount of time that we're being given to defend this. We have an expert who's here to testify. I will make a very brief legal argument, and then I'd like to put him on the stand to ask him some questions.
And Ms.
about
Bryant, I will have additional time if it's necessary to have a more fulsome evidentiary hearing, if that's what the parties think is necessary. Forgive me, but my sort of, we have so many affidavits that I've had a chance to review that I thought that the legal argument would be the focus today. And so, but again, I can give you more time. It's just not going to be today. It will be later this week.
Okay, well, how about this? I have 9 minutes. Is that what I understand?
You have a little bit, a little bit more time than that, because I got to make sure I have all my jurors, et cetera, but not much.
Okay, then I do need more time, Your Honor, to put, and the problem is I don't know that my expert is available later this week at this point. But let me just briefly get into a couple things. I still don't believe that Mr. Howard has met his threshold requirement of letting us know what fees are actually attributable to the allegedly sanctionable behavior. His client made a counterclaim for ownership of this disputed area. So had the original petition only claimed some sort of declaration of rights under the less than accept language, which the court indicated would mitigate and likely no fee award would be granted, how would he have defended this case any differently? I don't think he would have. I don't think that, I think Ms. Cummings thought she owned that property. I think that's what motivated the trips to the city of Atlanta and the discovery on the city of Atlanta and much of how the case was defended. So I don't believe that we have gotten a clear articulation of what exactly was the problematic behavior that caused his fees to be more than they would have been otherwise, when clearly there was a dispute as to title to this area. Given the time, I'm going to, and the uncertainty of whether Mr. Schneider is available later this week, I'd like to put him on the stand and go through my questions with him. And if the court would grant us additional time, I have an extra or another expert witness on the reasonableness of these fees that maybe can be heard at a later time this week.
Okay.
So, Mr. Schneider, Ms. Warner, would you swear him in, please?
Ms. Warner, we can't hear you, so I'm going to swear in the witness. Mr.
Thank you.
Schneider, thank you. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God, sir?
I do.
Thank you, sir. You may lower your hand.
Hey, Jeff, I'm a fast-talking New Yorker, so I'm going to
No
get put to the
problem.
test. Are you
I'm in New
ready?
Jersey, Jeff.
Okay, please state your name for the record.
Jeff Schneider.
Are you a licensed attorney in the state of Georgia?
I am. I was admitted in 1989.
What is your area of practice?
Real estate title litigation.
What is your current role?
Current role in terms of
At the firm that you're at?
Weisman. I'm a shareholder and sort of a founder.
Okay.
Since
How long
1994, yeah.
How long have you been in practice?
Since 1989.
Okay. What is your background in securing marketable title?
I have been a major claims counsel for all national title insurance companies that issue policies in the state of Georgia. I have engaged in title clearance work such as this for the last 30 years. I'm the former chairman of the real estate section of the state bar and was on the executive committee for a decade and was just rolled off as a senior advisor to that section. I have served for the last decade on the formal opinion advisory board for the state bar as its real estate representative, which drafts opinions relating to the application of the rules of professional conduct. I've spoken at dozens of real estate seminars locally and statewide governing real property title specific issues. And I serve as a special master in Fulton County, and I'm the owner of a mediation company called Real Property Resolutions, which is just title and real estate specific mediation service.
Okay. Are you familiar with prevailing market rates for legal services of this nature in the Atlanta marketplace?
I sure am.
Okay. Have you previously served as an expert?
I have.
Okay. I've previously submitted your bio into evidence, so I'm going to skip through that step right now.
Ms. Bryant, forgive
yes.
me. Let me ask you a quick question. So one, I have no question about Mr. Schneider's ample qualifications to be an expert in this particular arena. But my question is the dispute that I understood the dispute to be that Mr. Howard did the scope of the work he did and not necessarily his hourly rate. Is that accurate or no?
We're not disputing his rate, Your Honor. We're
Okay.
disputing the amount of time that has been spent on.
That's what I thought. I just
Right.
wanted to make sure that I was clear on that. Thank you, Ms.
Yes.
Bryant.
Thank you. Mr. Schneider, have you reviewed the pleadings and the motions filed in this matter?
I have.
Okay. Briefly, what is your opinion of the manner and method in which this lawsuit was initially filed?
Judge.
I'm sorry, was that an objection, Mr. Howard?
Yes, Judge. I understand that Your Honor is comfortable with Mr. Schneider as someone who has expertise in real estate litigation, but I don't think it's been established, and neither has he been admitted as someone who has real estate expertise in this litigation.
Well, I don't know that someone can have expertise in this litigation, but he certainly has real estate expertise, and it sounds like sufficient. Do you want Ms. Bryant to just ask the question and then make the motion so that I can make it official? Is that your objection?
Well, part of my objection is that he has not been admitted as an expert witness in this case. And then the other part of my objection is that if he's going to be admitted as an expert witness in this case, I might like to reserve the right to do some voir dire about that. But maybe we should just let Ms. Bryant ask her questions and then take it up after, if that.
Ms. Bryant, why don't we do this? Since everybody is, I think the court had a very different expectation of what this hearing was going to look like than the parties did. And so I apologize if I was unclear or if I didn't adequately allow for time. Ms. Bryant, you mentioned something about Mr. Schneider's schedule. So I have this case, the criminal case I am trying, I expect that will be in the hands of the jury tomorrow. And so I will have the ability to deal with this case and give you an hour or, however much longer it requires. But I think there's a limit on how long this should take, even with unlimited time. So what is Mr. Schneider's availability in terms of trying to do this at a different time by Zoom?
Is that question for me or for Mr. Schneider?
If either one, you can answer
Sure.
for him as your proffered expert, or he can tell me himself.
Yeah, I'm sorry, I don't know his availability specifically, so he'll have to answer it.
Sure. I have a hearing tomorrow morning, which should wrap up by noon. I have a shareholder meeting, which I would love to avoid. Tomorrow afternoon, I'm clear Wednesday and Thursday and Friday of this week. Be glad to make time for this whenever the court's available.
Mr. Howard, what are your thoughts, sir?
Judge, I'm flying to Miami this afternoon for all-day mediation tomorrow. I should be back Wednesday midday. I would think Thursday or Friday I could be available.
So I can definitely accommodate you guys on Thursday morning if that's something that you want. Because here's what I see happening. It's 9:59, and even if I was going to give you a few more minutes, Ms. Bryant has already expressed that she has concerns about the amount of time the court had afforded her, although I do think there's an outer limit on the amount of time this should take. I've got the affidavits, et cetera, but I'm willing to let you make the record that you want to make, number one. Number two, now even that is in jeopardy because Mr. Howard is not, he might want to voir dire the witness regarding his expertise to have opinions about real estate and title and attorney's fees litigation associated with that. And so, or the work at least done in service of it. So it seems as if what we need to do is move this matter to Thursday morning. What does everybody say about that? Thursday morning at 9:30? At which point you would have, I can accommodate 2 hours, but if y'all went on for 2 hours, I'd probably be a little bit annoyed, but just being honest. Mr.
I have no
Howard,
intention of going on for 2 hours, Your Honor.
Ms. Bryant, again, always a fast talking New Yorker, but also a very fast talking lawyer. So I don't doubt it. Mr. Howard, what are your thoughts, sir?
Judge, my thoughts are just that if we knew what Mr. Schneider's opinion was, we may or may not want to voir dire him, but I have time at 9:30 in the morning on Thursday. That would be fine.
Well, the way this hearing is shaping up, getting Mr. Schneider's opinion might take more than the 5 or 10 more minutes that I have to give you guys. So my apologies. I am going to have Mr. Freehoff issue a notice of continued hearing, and it will be at 9:30 on Thursday, December the 11th. And I appreciate everyone's flexibility and understanding so that the parties can have the time that they believe they need to put on this presentation. Okay?
Thank you,
Thank
Your
you,
Honor.
Judge.
Okay. So as I said, should be getting that here in the next few minutes. Mr. Freehoff will send out that notice. It will also be by Zoom, and I will see you Thursday morning at 9:30.
Sounds
Thank you,
good.
Judge.
Thank you.
Thank you, Your Honor.
Bye-bye.
Just before everyone gets off, are we going to be splitting takedown? Or can you all hear me?
Yes, I can hear you.
Okay.
Mr. Howard, are you splitting takedown?
Let me respond offline once I have a chance to talk to my client about that.
Okay. I guess for
Okay.
now, I requested your services, Ms. Warner, so for now you can send me the invoice, and then I'll wait to hear from Mr. Howard.
Yes, ma'am. Sounds good. I hope everyone has a great Monday.